Good evening and welcome to tonight's show. I am your host, Tina Dawson, and the owner of True Blue Designs, and it is truly an honor to be before you this evening. Tonight's show is you're in for a treat. Get your pencil and your pen and piece of paper because tonight's guest is going to give you a lot of good information. Now, please like and share and let everybody know that we're on the air. We are streaming live on YouTube and on Facebook at True Blue Designs. Now, the intellectual property system aims to foster an environment in which creativity and innovation can flourish. When choosing to protect your intellectual property that you created, you must start by determining what type or types of legal protection that may be available and appropriate for your situation. These types of questions are most appropriate for an intellectual property law attorney. Tonight's guest coins herself as the trademark connoisseur and is here tonight to give clarity and answer questions you may have about your intellectual property. Please help me give a warm welcome to tonight's guest, attorney Ashante Rosier-Robinson. Hey, how you doing tonight?
I'm doing well. How are you?
I am doing great. Thank you so much for saying yes to joining us.
Of course. I'm happy to be here.
Thank you. Well, we're going to start off by asking, how's your family? How's everybody doing?
Everybody's doing really good. My daughter's running around in the back, so if y'all hear anybody yelling, it's her. My mom's doing good. My brother's doing really good too. So,
well, make sure you tell them I said hello.
I will. I think my mom's watching.
Well, hey, her mom is my CPA, Miss Ashante Rosier-Robinson. She was on show number 3 when we first started everything. So thank you for being on the show. Now, we're going to start off by allowing you to tell the audience a little about yourself.
Well, I'm Atlanta native, born and raised. I went to undergrad at Furman University in Greenville, South Carolina. And then after that, I went to George Washington University Law School in DC. I moved to West Virginia for a hot second, and then I came back to Atlanta, and then I started practicing intellectual property when I moved back here to Atlanta.
Okay. And so what interested you? Because there's so many different types of law. So what interested you to go into this specific area of intellectual property?
It was actually by accident at the firm I started working at. Once I got my license, they did full-scale business services. So they did contracts, intellectual property, LLC formation, and one of the attorneys I was working with just decided to show me how to do trademark applications. Mm-hmm. So after that, I just kind of got really interested in it, and it just really piqued my interest. And so I went further with it and just started learning more, practicing, like going to CLEs, and I just ended up really liking it, which is hilarious to me because I skipped every single day of my intellectual property law class in school.
And it came full circle. So for those that do not know, can you explain what is intellectual property?
So intellectual property itself, it kind of came about to describe ideas or things that people design or something like that. So people were, creating these hair scrunchy things, pens, headphones, brushes, stuff like that. And so, and then music or writing books, that kind of stuff. And there was nothing out there to protect it. So that's how we got intellectual property law. So it protects and enforces the rights of creators and owners of inventions, writings, music, design, and many other works.
Okay. So what are the various types of intellectual property that a person can put in an application for?
Really just about anything. So anything that you create or that you brand yourself with, you can probably either trademark copyright or patent it. So, and there's also this thing called trade secrets, which is a little bit different than all the other three. So, but there's that too for like if you have recipes or like secrets that are behind your brand, like Coca-Cola has a trade secret for their recipe of their soda.
Okay, and like KFC, is that
Yeah,
like
their
chicken
spices and and like Dr. Pepper likes to say they have 23 flavors or something like that. Like those are the type of things that you would protect with a trade secret.
Okay, so you discussed what a trade secret is. Let's talk about, you also mentioned trademark, copyrights, and patents. So can you tell us, you give us a little definition of the difference of the three?
So I can start with patents because I don't do patents, so I don't know that much about them because you are required to have a hard science background for patents. So I don't do those, but they're usually for designs or fashion or something like that. Like if you come up with some unique fashion idea, you can patent it, or designs more so for patenting stuff, or sometimes code. So it's a more technical aspect of trademark or intellectual property law. So that's why they want you to have the sciencey background. Like I don't know anything about patents at all, except that I can't practice them. So that's that. So if you are ever looking for a patent, seek a patent attorney specifically. They have to be they have to take a test to be able to practice in front of the USPTO and everything. So they're certified. Trademarks are basically, you can do words, logos, and sometimes what they call trade dress, which is how your goods or services appear in a box. Like if it's unique enough to appear a certain way, you can get a trade dress for it. But most of the time people do word marks or logos, and the word marks are usually the name of your company or slogans or something like that. And then logos is pretty much whatever you put on your goods or services. Like I'm doing one currently for a coffee company, and they drew like a character that they put on their coffee bags and stuff like that. So that is the logo that they would do for their company. Okay. Copyrights are for more tangible objects. So you can do it for pamphlets, poetry, planners, books, those kind of things. You can copyright like the book itself, but not really the idea. Like you can't copyright ideas, but if you have like tangible objects that you can send in. I've done one for a game board. So that one, there's a whole gambit of things too. Like they list out a number of things you can copyright, but for trademarks, it's more succinct. Like it's logos, words, and trade dress. But copyright, it's more for artists. Like you can also copyright logos too, but the protection isn't as long because they have this whole thing about coming out into the public domain and all that stuff, which gets really, really technical. But copyright protection, I shouldn't say it's not for as long. Copyright protection, if you do something for it, it lasts for a long time, but your protection starts to dilute after a certain amount of time, which is why they do it for things that like educational materials, those kind of things that don't require as much protection, but you still want people to know, like, I created this. Right. This is my right. Like you can make money off of it, basically.
Okay. Let's talk about. I think I have an echo. Do you hear an echo?
No.
Oh, okay. So trade dress. So like Coca-Cola and their Coca-Cola bottle, their can. So is that the bottle?
Yeah, the one that's like a Coke shaped bottle, that will probably be something that is trade dress protection.
Okay. And then the Coca-Cola logo, which is the word, that's trademark.
Yes.
Okay, I got it. Okay. And usually how long, once you get a trademark, how long does the trademark last before you have to renew it, or do you have to renew it?
No, you can renew it. So they have a time period of about 5 years. The first time, once you get your first registration, after that date, you have to renew after 5 years, and then after that is every 10 years.
Okay, so first 5, then 10.
Yeah.
Okay, now I know one thing I know that is copywritten, like you said, the books, like if you're going to school, your books, your textbooks, music. I know artists copyright their music.
Yeah.
Someone told me one time ago, and I don't know if it's a myth or not, but they were saying that if you mail yourself whatever it is and do not open it, that's a form of copywriting. Is that true?
That's not true.
Okay,
I've never even heard of that, but whatever, that is not true.
Okay.
And honestly, getting something copywritten is not a super expensive or hard process. Like they kind of make it so that lay people can do it on their own if they want to. Especially if it's something simple like a manuscript or something like that, because all you do is upload it to their system. They make that part really easy. You just upload it to the system, and then they get back to you in like 3 or 4 months to let you know if you have a registration.
Okay. Yeah, because a while ago, somebody was saying, like you were saying, if you have a manuscript or something, if you mail it to yourself and then you don't open it, and you make sure you have it postmarked, right? And you don't open it, that's a form of copyright. So see, I'm glad I talked to you.
Yeah, I've never heard of that. Now I'm gonna go Google it after we get off of here, because I'm interested in that.
As long as you don't open it.
Yeah, I've never heard of
you don't open it, then you can prove that, I guess, that was your idea, and you have it postmarked from when you sent it to yourself. Now, there's a lot of myths that goes around. So
yeah.
I'm glad I asked you. So if you're going to get something copyrighted, you need to go to an attorney that is licensed in copyright law and let them take you through the process. And I'm glad that I talked to you about this. And I know you don't do patents, but I want to tell you a quick story. So I was in my early 20s and I had came up with this idea. And it was a way to enhance a high chair tray. The high chair and the tray.
Mm-hmm.
So I drew it up, everything, and there was a company off of Lenox Road that said, if you come to us, we can help you with patents, right? Didn't say they were attorney. I was young. I didn't know. So I went there on my lunch break and took my idea, came back. My boss said, where did you go for lunch? And I said, well, this company down on Lenox Road said that they would help me. And he said, go back and get what you gave them, because they're going to take your idea. And believe it or not, Ashante, that December in the Toys R Us book was my idea. And I still have the magazine, because, back in the day, the magazine was small. It's not, the thick book that they've had in the later years. But my idea that I gave them was there. So you have to really be careful to protect your idea and to go. And like I said, these people were not attorneys. They were just a company that said that they can help you. And I don't know how many other people's ideas that they stole. Yeah. And I didn't know. So, when you don't know, you don't know. But, when you don't know, it can hurt you. Because I'm sure they made a lot of money off that. So, yeah, you need to go to an attorney.
Yes.
Okay. So, now I was reading up on, came across something called industrial designs and geographical indications. Those types of things that you can get trademark, or those types of intellectual properties, or.
So they are. An industrial design is similar to a design patent. So I've never done any of those, but they kind of run in the same family. So you would want to see a patent attorney about that, because I don't know that much about them. But they provide protection, obviously, for designs like 2-dimensional or 3-dimensional things. Okay. So that's not my thing.
I got you.
But for geographical the indications, which can also be called certification marks, those are similar things. You can apply for that through the USPTO as well, and there's for overseas places, they have them for through the world. What is it called? The World Trade Organization. They do stuff like that too.
Okay.
But basically, it's one of the things that they identify a good as originating in a territory or a country or a region or somewhere. So they have them for Florida oranges or Idaho potatoes or Vidalia onions, like those kind of things. So that you see them, you know, they're going to be this. They're going to taste like this. It's going to be this type of quality. So that's kind of what those are for.
Okay, so that's a geographical indicator.
Yeah, or a certification mark.
Certification mark. Okay. See, that's good to know. So when you mentioned the USPTO.
Yes, United States Patent and Trademark Office.
Okay, talk a little bit about that.
So for the United States, they are the ones who house trademarks and patents. So if you want to do a trademark or a patent, you have to go through them. The other countries have sort of more of a disjointed way of doing like foreign trademarks. Sometimes you have to do it by country. Sometimes you can do it through a protocol depending on what they have. But for the United States, you do them all through the USPTO. Like they have a database where you can search for what trademarks are currently pending or registered or have had an application come through. I assume you can do the same for patents. I've never done so, but they have a database for patents as well.
Okay. Another thing I want to bring to your attention that I think is a myth. So when you are going to get a business license in Georgia, right? So you're going to get a business license, and it's for the bucket shop. Just for an example, right? So you go and you get an LLC or INC for the bucket shop in Georgia, right? So my question is, can't someone open up the bucket shop, same name, in another state, right? Because that LLC is just for that particular state. Is that correct?
I believe that to be true. The states don't cross-reference with other states, so there could be the same name of a company in like 3 different states. But if you get a trademark for the bucket shop, which you would not, nobody apply for that. It's too descriptive and generic. But if you had a trademark for the bucket shop, you could stop other people from using that name in other states. Like, because I don't know if they would have a sign or something that called the bucket shop, but if you had a trademark for that, you could stop them from using it.
Really? Okay. Yeah. Okay. So that's good. Now, you just mentioned that the bucket shop would be too generic in the name. So can you explain to the viewers a little bit of the beginning of the process that one has to go through? Because just because you come up, say, if I come to you and I say the bucket shop, I may not get the bucket shop. I may have to tweak the bucket shop in order to get the trademark. So can you go over a little bit of that information?
So when you want to apply for a trademark, when they're evaluating them, they have a spectrum that they evaluate marks on. There are what they call fanciful marks, which are the strongest in their opinion because they are usually made up words or something like that. Like Xerox was a made up word when it came out. And so it was trademarkable because it didn't describe any services. It wasn't a generic word. It was completely made up, had no meaning. And then they were selling copiers, right? Yeah. So, so they had a trademark for that. Now it's kind of become diluted and generic. When someone says they're going to Xerox something, they're going to go copy it. So it's not really trademarkable anymore. But at that time, it was unique and fanciful. So it had the strongest protections. And then on the very weak end are generic marks, which they won't even let you register. Okay. So it would, like, if you sold houses and you called yourself the house seller or something like that's not going to work because house is generic and you sell them. So like that's just not going to work. Then somewhere in the middle, you have other marks. Like descriptive marks can get registered, but it takes a lot more work to overcome like a descriptive mark. Mm-hmm. But then people usually fall into the area where they have some unique identifiers to their name, but also have some descriptive terms, which is somewhere in the middle. So what you want to do first and foremost before you even apply for a trademark is to have an attorney do a search of the trademark database. It's called TESS. TESS is an acronym for something that I don't ever remember. But TESS houses every application that has ever been sent into the USPTO. Okay. So you like live marks, registered marks, abandoned marks, they'll all be there so you can see them all. So if you have an attorney do a search, they will find any similarly confusing marks to yours and then evaluate the risk of those marks to being a bar to your marks registration. Okay. So that's step one that I think everyone should take. And people always tell me, oh, I did a search, I didn't see anything out there, but your attorney's looking with a different eye and like knowing the different standards that the examining attorneys are going to use as well. So I think it's always important to have an attorney do the search. Even if you go do the application yourself later, you should have an attorney do the search. So you want to start there.
Now, what if the attorney does the search and could the attorney come back with some, say if we're going to use the bucket shop. So say we gave you the bucket shop, you did your search. Could you come back and give us some suggestions? Say, okay, you might not can do the bucket search, but you might want to try, the bucket search, something else, give us some suggestions of what we could do, or maybe not even use the bucket store.
Yeah, so some attorneys will do that. They'll go back to the drawing board with you and like brainstorm and come up with a more unique name for your brand. There are some who will do that. Depending on the situation that my client is in, especially if they haven't started using the mark already, I would brainstorm with them and let them know like, hey, maybe we need to go back and do this. You need to add this kind of word, whatever, to like help them make their mark more registerable.
Now, what if they have started using it? Then what do you do?
So it's really hard to convince people who have already been using their mark for any amount of time that they need to do something different. Yeah. It is very, very hard, but sometimes that's the harsh reality, especially like if you come too late and someone has either started using the mark before you and applied before you, or someone has registered a mark that's too similar to yours for yours to get registered. Like it's a hard conversation to have with clients because no one wants to ever change their mark. Like it's like, I've been using this for 2 years. Like this is my brand, like blah, blah, blah. It's really, really hard. But sometimes you do just have to go back to the drawing board. Like you just have to rebrand, which costs money and all that kind of stuff. But you would rather do it when you're 2 years in versus 10. So
right. So let me ask you. So what if someone? I don't know why I'm getting this. Let's see. Hold on. Can you hear me?
Yes.
You can hear me?
Mm-hmm.
Okay.
I don't hear it echo.
I don't know what it was, but anyway. So what if you search for the name and say you've been in business 2 years, right? And you go to an attorney, you want to get a trademark, they do the search, and come to find out somebody just got a trademark for that name. Can the person who just received the trademark for the name stop me from using it?
So yes and no. So okay. It depends on the situation, which I know people hate when lawyers answer like it depends, but it really does depend on the situation. So it depends on if that person who got the registration, how long they've been using their mark, and how well they police their mark. So once you get the registration, you have to be the one to stop other people from using your mark. Like,
Okay.
no one's going to police your mark for you. And if you let a bunch of people start using your mark, then your protection lessens, because now the mark is kind of diluted.
Yeah.
But so it really depends. Like, people, I've seen this question in some of the trademark groups I'm in. So it just depends on how, like, if that person hasn't started using that mark yet, then, and you have been, so the person who wants to get the trademark has been using that mark for, let's say, 5 or 6 years, and the other person hasn't used it at all, like they plan on using it in the coming year, then the person who has been using it the longest can, what they call, oppose or try to cancel the person who just got a registration because they've been using it longer. Like, they have priority of use is what they call it.
Okay. And
so, but it's a nuanced situation. It's going to be different for every brand, because everyone's situation is different.
Right. And if you come across that, you do need an attorney. That sounds like you would need an attorney. That's not something that you need to try to fight yourself.
No, you are required to have an attorney if you want to file any kind of suit in front of the USPTO. You have to have a practicing attorney there.
Okay.
Of record.
And let me ask you this. So who owns intellectual property, and how is ownership determined?
So the owner of intellectual property is who the registered owner is on your application. So if you register for like I have a trademark that's registered, and my company is the owner, though, because I recommend people have LLCs to own their marks for additional layers of liability protection. But like, my company is the owner of my trademark, but I'm the only owner of my company. So I essentially own my trademark. And then the same thing for copyright registrations. The person who's listed as the author is the owner. Now, it gets a little, weird if you have more than one author to something. Then, you can split rights. Or if you have what they call works for hire, which is what happens when you're an employee for someone and you make something throughout the course of your employment, that is generally owned by your employer, not you.
Right. Okay.
So that's those kind of things. And then sometimes what people don't realize is when people create logos for you, the graphic designer is technically the owner of the logo unless you get them to release their rights. So those are things that you have to think about. Like, if someone creates something from you, you need to have them sign something that says they're releasing their rights, so that you can now be the owner or register it to be owned by you.
So if you go through there's a lot of companies out there that do logo services, right? So those companies own the right to that logo, correct?
Yeah.
And you just pay them to get a copy of what they created for you, but technically that company owns the right of the logo.
Right. They have copyright rights in that logo.
Copyright rights. Okay. Yeah. So and they also have the ability to reuse that logo. Am I correct?
Yes, because it's theirs. They technically have the rights. I mean, you paid for it, but you didn't pay. You paid for their services, not for the rights to the logo. So you really just have to send them. It's like a pretty standard release to have them sign for you to then be the person who can establish rights in that design.
But you should get that. Am I correct in saying that you should get that statement signed before they start work? Am I correct?
I've done it both ways. You can do it both ways, because you may not end up getting a logo from them. Like, something could happen. Like, you don't end up liking the design, and so they keep it for whatever reason. So I've done it both ways.
Okay. And I'm glad that you mentioned that, because I actually, when I first started my business, True Blue Designs, that actually happened to me. I went to a local company and I designed something for a client. And I went to a local company and gave them the sketch and had them to came up with it, the graphic design of it, right? So they created it. And then they put it on the garment for me. And the client came back and said, well, I don't want them to use it
Right.
on any other for anybody else or for their use. This is my design.
Right.
Well, I did. I went to a friend of mine who's an attorney, and he said that you should have gotten all of that in writing, before you went ahead, because they own rights to that image, and they've used that image over and over again and made a lot of money. But it was nothing we can do because we had nothing in writing.
Yeah. So I mean, really, like when I had my logo design, this one actually, part of the package was that she sent me a release of the rights to the logo. So it kind of, like I said, it depends. And then I've done one for someone who had a logo done by a graphic designer at some point, but now he wanted to trademark and copyright and do all this other stuff. Well, I'm like, well, you need to have the graphic designer sign this. And because they were friendly with the graphic designer signed it, released their rights. So it depends on what your relationship is with the person, how much you trust them to do the right thing, which I always tell people not to trust people to do the right thing. But so it just kind of depends.
Okay. Let's see. Okay. So what works are not protected by copyright?
I don't know. There are so many things that you can copyright that I don't even know what wouldn't be included in that. Like I will say you can't copyright ideas. Like it has to be something that you can upload and send to them. Like people like to think, oh, I wrote a story, let's say about the Twilight, like the vampire and the wolf thing. Like that story has been done so many times. Like you can copyright your book specifically. So like everything you wrote, but you can't copyright the idea of like vampires and werewolves living somewhere in the same city, falling in love with humans. Like you can't copyright that idea, but you can copyright your tangible book and your story that you wrote. So I will say that's what I know for sure you can't do is copyright ideas.
Okay. What about quotations? Can people copyright quotes? Like if they came up with a quote or a saying that they came up with, is that something that they need to have searched before they copyright it? Or
so maybe if it was like a book of quotes, I wouldn't, or like poetry, like a book of poetry, you can copyright, or a single poem you can copyright. But so far as like a quote, which I will refer to as sort of a sloganish type thing, that would be more of something to trademark than to copyright.
Okay, gotcha. Okay, and Stacy had made a statement. She said, "And Olin Mills picture companies own your photos. You just purchase the copies."
For what?
Olin Mills.
Oh, okay.
When you go to get, that's an old company. I don't even know if they're still in business, but that Olin Mills was a well-known photography company, had locations everywhere. And when you go and you sit and you take the pictures from them, she was saying that those companies own your photos, but you just purchase copies of them. So that's basically what you were saying.
Yeah, because it's just like when kids do school photos or something, like you don't own those pictures. You can just buy them because they use them for advertisement. So
yes. Okay. Yeah, that is saying. And Olin Mills used to be the ones that came in schools long time ago, but now there's different companies now. Life Touch, Prestige, same thing. So they own the rights to the photos, but we purchase copies of the photos. Okay, all right. Okay, when choosing an IP attorney, what are some questions that we should ask or things to consider?
I would consider their area of specialty because, like I said, for patent attorneys, they generally only do patents because they're difficult and they take a really long time. Like I met a patent attorney recently and she said sometimes patents take 2-3 years to get and you have to know what you're doing. And so you can't just go to anybody for that. So I would look at what they specialize in and then just kind of ask them about what they have done in the past so that you can know if they can help you with what you've been doing. Because sometimes, like, I've never copyrighted music. I don't even know where to start with that. So I wouldn't tell anyone that I can copyright their song for them, because in the event of some copyright infringement, you would need to be able to explain or like read music, and I can't do that. So I wouldn't copyright music for anybody or code or anything like that, because I don't, that's too technical for me personally.
Right.
So people who usually copyright songs and stuff like that, they specialize in that kind of thing. So I would look for specialties, ask them questions about that specialty specifically. Like, I've done a lot more trademarks than I have copyrights, but like, I can copyright like publications. Like, I've done planners, like I said, I've done the game board. I could do brochures and that kind of thing, or like learning materials, but I wouldn't do anything too technical. Like, you can do like what are they called them, the architect sketches, like engineering sketches and stuff like that. Like, I wouldn't even go anywhere near that because I can't explain it. So that kind of thing. And then with trade secrets, usually patent attorneys do that kind of stuff too, because it gets a little technical. And I've never done a trade secrets thing, so that's not something I would really do on my own. But then trademarks, like, I could tell you about the trademark application process, what the application is like, what the examining attorney is looking for. So you want to ask them those kind of questions, attorneys, those kind of questions, like, what is the standard for, what standard are examining attorneys using when they're evaluating your application? Or how likely do you think my application is to be registered? They're going to give you a vague answer because they have to, but you still want to ask them those kinds of things. So those kind of questions would be important.
Okay. And what is an estimate in cost for people looking to get things trademarked? What is an estimate? And I know it depends on the person's situation. But you know, I know from personally, it's not cheap, but it's worth it, because you have to look at, you know, I can tell everybody, you know, you're my trademark attorney. But when you sat down and you explained to me the process that it takes, you understand why you have to write the type of check that you got to write, right? Because it's not an overnight process. And to me, it's something that you have to have patience, right? Because it's not a overnight process. So can you just give like a ballpark figure, maybe looking between this and this, just on the low end of what people may look at just to begin their trademarking?
I would say on the low end, I've seen anywhere from 1,000 to 3,000, or like 3,500, depending on the size of the firm and how long the person has been practicing, those kind of things. I'd say a good range is anywhere around $2,000. Like, that person is probably well versed, knows what they're doing, and could really help you. But then I've seen it go as high as like $7,000 or $8,000, depending on the firm and the package that they provide. So it really depends on what you're willing to pay and what you're comfortable with. You could find someone in your range. And I know a lot of people do payment plans and stuff now, because if you don't have a favorable search, then no one is going to make you do an application for that mark, because that would be a waste of everyone's time and money.
Right. Okay. So that's good. I mean, that's, to me, good information, right? So they can have some type of ballpark range of what they're looking at when they're thinking about going down the road of getting something trademarked, copywritten, or maybe licensed. Now, let me ask you this. What is the difference between a TM trademark and an R registered trademark?
So TM is what you use when you're letting people, like, putting the public on notice that you're going to pursue trademark rights, and whatever the mark is that you put the TM next to, you start using the R after you've gotten an official registration from the USPTO.
Okay, see, I didn't know that. I was wondering why some had TM and some had R. So
yeah, so it can either mean you have a pending application or you plan to apply for a registration.
Okay, so TM is pending and R is I've already gotten approval.
Yes.
Okay, see, didn't know that. That's pretty good. And look, if nobody else is getting something, it's me now. I just want to tell the viewers, put your questions in the comments. We'll make sure that Ashante gets a chance to answer them during the show. But put your questions in the comments and make sure you like and share. This is good information. Okay, so when does a person need to pursue international protection?
I would say if you're a big, like a really big brand who plans to sell and advertise internationally, but if that's not your plan, I know people will say, "Oh, well, I'm on the internet. It's, that's fine. You don't need an international trademark just because people in other countries can see your stuff on the internet. You don't necessarily need that. But like if you are like Amazon has foreign trademark registrations, but I don't think it's necessary if you don't advertise and sell in another country. Like if your stuff is going to be contained to the United States, you're fine with a United States trademark registration.
Okay. And then you mentioned Amazon. So let me ask you this. So since Amazon sells internationally, do they have I'll call it domestic trademark and an international, or is there one trademark for both?
No, they have both. They would have domestic and foreign registration, which you can do through the USPTO. Technically, they have. This gets way more technical than people need to know, but they have this thing called the Madrid Protocol, which is sort of an agreement with the other countries that you can apply through this system, but you still have to keep track of it through the European countries. Kind of have their own thing. You have to keep track of it through their system, and they will communicate with you about what's going on with your trademark. Just because you have a United States trademark doesn't mean that you're going to be guaranteed a foreign trademark through this protocol. And vice versa. Some people start off getting foreign registrations and then apply for registration in the United States on the basis of that foreign registration. So it goes both ways, but it's more technical than I need to get into right now.
Okay. But that's good information though. Because like you said, somebody as big as Amazon, they have to get two, right? Yeah. They have to have a foreign and a domestic patent trademark, right? Because they're selling here in the United States and they're selling international, right? Okay. So I was reading up on and came across a term called a patent troll. Do you know? Can you discuss a little bit of about that? And then is that something that if someone is, I guess, interested in going down the road of getting a patent, is that something that they need to ask attorneys if they defend against patent trolls?
So I assume a patent troll is kind of the same thing as a trademark troll, where they kind of just apply for a bunch of things to be the owner of this. So with trademarks, China did this a lot, which is why they made some new rules to combat that. But they would basically file applications and kind of make fake proof of use and get registrations just so they would have a hold on whatever this was. So companies in China were doing that a lot. I assume the same thing is for patents. And yes, there are ways that you can combat that by trying to show that this is not a legitimate patent or trademark and fighting it that way. But it is a little more expensive, I will assume, on both ends. But yeah, you have people who just want to buy stuff up so that you'll have to come to them to get this. Right. The same thing with people who sit on domain names and stuff.
Yeah, I'm gonna ask you that. Yeah.
It's the same kind of people. They just are trolling, like you said, the internet or stuff, looking for, or sometimes people will see something become popular and they'll go try to trademark it first, even though they did not come up with that idea. It happens a lot now with the internet and on Twitter and social media, where people say something funny, it becomes a meme or a line that people use all the time, and then they go to trademark it and someone else has already done so.
Right. Isn't that crazy?
It really is.
Yeah, I've seen it with the internet domains.
Hmm.
But when I was reading about it, I didn't know they call them trolls.
Yeah, or squatters, like for the people who are the domain people, they call them squatters.
Mm-hmm.
But yeah,
Yeah,
it's
that's
common
crazy.
enough that it has a name, and people, they're starting to make rules against it because
Mm-hmm.
they're not fulfilling the, what is it, free business, like, competition, like that. It's not fair for you to buy up all of these things and just
Right.
wait for people to come to you like, yes, I own it, please buy it from me, even though they're
Right.
not using it.
Yeah, and I've seen situations where like professional people will have, like, I think Steve Harvey had a domain name and then, or tried to get one or something, and then he had to switch it of what he was using so people knew that this is my actual domain. Some other people may have something that's similar,
Similar.
Steve Harvey, but he had to say, okay, no, this is my actual domain name. This is my actual, that's tied to my actual website. And you had people, like you said, that was buying up
Hmm.
names, his name or something similar
Similar
to what
enough.
he had, Steve Harvey 12 and stuff
Right.
like that.
Yeah.
Crazy, crazy. So you are the owner of the Rosier Law Group. So
Yes.
let's talk about your journey to becoming a business owner and opening up your own law firm.
It was honestly pretty spur of the moment. I think I was sitting in my mom's kitchen and we just, I was actually doing some work, contract work for someone, and I didn't want to do it in my own name. So I just created an LLC to do so. And then kind of since then, when I decided that I wanted to do intellectual property, I just started promoting myself under this name with this brand. So there was no, I wish I could say there was some thought behind it. There was
Mm-hmm.
none. I was just sitting around. It might have been right before the pandemic, and I was just sitting around. I was like, yeah, well, let me do this. And there's no reason for me not to have an LLC when it only costs $50.
Right.
So, so that's really how it happened. And then I just started building a brand around the name.
Mm-hmm. And there was no thought behind it, but there was an opportunity behind it.
Right.
Right.
But there was opportunity, but there was zero planning. I wish that
Yeah.
I could say there was some kind of planning. There was not.
Yeah. Yeah. But I'm sure that now that you've had it, you see, the potential of you being able to, like you say, brand yourself
Yes.
and offer, offer services, under your own name and under your own brand. So let's go over once again what services that you offer under the Rosier Law Group.
I do trademarks, copywriting, I draft contracts, and I do LLC or business entity formation of all kinds, which is really, I really only recommend LLCs to people, but I also can form corporations. So.
Okay. Okay. All right. That's a lot of services. Okay. So yes. So if anyone has any questions for Ashanti, please put them in the comments. I'm sure she would love to answer your question. She covered a lot of good information. So, is there any last tips or anything that you would like to, or information that you would like to give the audience about the topic for tonight?
The only thing I want to say to people is that if you're thinking about, even if you're just thinking about starting a business, or you have been using something, a slogan of some sort, or a name of a company or some sort, like out branding yourself that way, or you're planning to, just get the trademark. But sometimes people are hesitant because of the cost, or they're
Mm-hmm.
hesitant for any other number of reasons. But then the moment you hesitate, someone else is applying for that. There have been a incredible amount of trademark applications over the past year and a half. I don't know if during the pandemic everyone just decided they were going to start businesses, or they were getting creative in their homes or whatever, but the number of trademark applications has gone up so much that the process is now taking almost 18 months
Oh,
to
wow.
complete. And some marks are not even showing up in the system immediately because they are taking so much longer to process. So if you are even thinking about trademarking something, just do it. Like, don't hesitate, do it. And then once you have the trademark, then you can build a plan. But
Right.
whatever idea you have, trademark it, copyright it, whatever it is, that whichever one fits best for your situation.
Yeah. Yeah. Like you said, just go ahead and get the process rolling, get the search started.
Mm-hmm.
Because you did talk about this earlier, that you may have to rebrand,
Yeah.
right? Because and another thing I've learned is you can't be too married to it,
No.
right? To the idea.
Well, especially I tell people this, especially if you haven't started using it. If you haven't started using it, it's easy to rebrand. Like, you just like, we can just brainstorm and come up with a different name. It's much harder if you've already been doing it. So if you haven't, and then I guess I could talk about this. The trademark office has two different types of applications for that reason. They have what they call 1B applications, which are intent to use applications. And then they have 1A, which means you're already using it and you're ready to show proof that you've been using it. But for people
Okay.
who like have an idea or like are not ready to launch right now, but they know that they want this name or this brand and it's available, file your intent to use application so that it's already in the pipeline, because it's going to take 6 or 7 months to get assigned to an examining attorney anyway. And you have plenty of time to plan in between that. So like, I tell people you have minimum 10 months before you even get to a point where you have to show that you're using the mark. So if you
Okay.
know that this is what you want to do and you know that the name is available for you to trademark, go ahead and do it.
Okay. Rebecca has a question. She says, "Do you ever need to have both copyright and a trademark?"
You don't have to have both, but you can have both. I haven't necessarily, so I guess um so there was this book before called like the 7 Habits of like highly effective people or something like
Mm-hmm.
that. So they probably have a trademark for that name, but then they also have a copyright for the book, because the 7 Habits of highly effective people, like, that's a thing. There was a theme because they had them for like students and
Yeah.
all kind of other things.
Mm-hmm.
So they probably trademark for that chain of names that they came up with, but then they also had copyrights for the books.
Okay.
So those kind of nuanced things, but you usually don't have to have both because they kind of cover different things, um, different areas of intellectual property. So I've never done both I did for the girl I did planners for.
Mm-hmm.
Her planners have her logo on them, but
Mm-hmm.
then we did trademark applications for her logo. So her planners got copyrighted with her name and logo on them, but then we also did trademarks for her name and logo.
Oh, okay. Okay. So let me ask you this. So what if you trademark some words, right? And then after you start the trademark process, you come up with a logo. And then you say, well, I want the logo. Now I have the name trademark, but now that I've created a logo, I want the logo created. But the logo idea came up after I started the process of trademarking the name. What happens in that situation?
So once you file your application, you can't change it. Like, so, well, they'll make you make changes if they want. You can only change it if they permit you to make a change,
Okay.
but you usually can't change the mark, what they call the mark. So if you did one for a word mark, they're not going to let you subsequently change that to a logo. You would have to do a separate application.
Oh, okay. So let me ask you this, and I don't know if you know the answer, but Coca-Cola was a word, right? But I guess the way they wrote Coca-Cola, right? What that makes sense because Coca-Cola is not just a word, right? Coca-Cola is really a graphic,
Right. So
right?
it can be both. So some people have word marks that are like Coca-Cola has a word mark, but then their design mark is the word in
Okay.
this design, like a nice font. So you can have
Okay.
both
Okay.
for that. So like your logo here at the bottom, it says True Blue Designs. Well, you could also have True Blue Designs, the words, just the words alone, and then you can have it in a logo format that also has words in it. So the logos don't have to just be elements like graphics. They can be script letters or whatever.
Okay. Rebecca has one more question. Let's see. She says, once approved, is the trademark good forever?
If you keep up the renewals, yes. So you have to, like I said earlier, you have to, when you initially get your registration, you have to renew 5 years after that, and then it's every 10 years. So if you continue to use the trademark or have what they call excusable non-use, then you'll continue to have the trademark. Because when you do that renewal, they ask you to submit again proof of you using it continuously for the last 5 or 10 years or whatever. So, but usually once you make it over that 5-year hump, like you're good when you do the renewals for the 10-year mark or whatever. But you have to continue using it. If you don't use it, or if there's someone who could show some kind of proof that you haven't been using it, then they will cancel your mark and you won't have trademark rights in it anymore.
Oh, wow. Okay. And let me ask you another question. Can you submit an application for the word mark and the logo at the same time?
No, they're two separate applications.
They're two separate. Okay.
Yeah. So you can do, and it's one mark per application. So you can do multiple classes per application, but it's one mark per application.
Okay. Hey, that's good information. I really appreciate you coming on the show. Like I said, a lot of myths,
Yeah.
So especially that one, and I know I'm not the only one that heard, put that manuscript in a manila envelope and postmark it and send it to yourself and don't open it. I want you to look that up.
I'm definitely going to look it up because I haven't heard that. I've heard of people, what they call the poor man's copyright, where they just put the C on something and think that means they have a copyright, but that's not a federal copyright registration. Everyone, whenever you create anything, even if you don't publish it, you have copyright rights, like common law rights, but you have to have a federal registration if you ever want to do anything about someone infringing on your copyright. For instance, like you can't sue anyone for copyright infringement without having a federal copyright registration. So you can create whatever you want and put it out into the world, and you have common law rights, but you have to actually register it to have those teeth behind the rights.
Right. Okay. Yeah. You make sure you look up my myth now.
I definitely am. Because I have never heard of that.
Years. I've heard that for years. Oh, don't even worry about going to an attorney. Just postmark it to yourself and don't open it. And I'm glad I asked you that because I've been told that a while ago, and I've heard of that for years. And now I know that's a myth. Don't do that. Call an attorney. Call Ashante Rosier-Robinson, and her information is down below. She's got a Facebook, an Instagram, and she's got her email down below. So if you have any questions concerning trademarks or intellectual property, give her a call. Ashante, thank you so much for saying you and coming on the show. I really appreciate it. And these videos are a resource hub. I call them a resource hub that people can go to watch the videos over and over again to gather information. And like you said, it's just not people going into business. It's just, people may have an idea of, like you said, a book of poetry.
Yeah.
And they might not want to necessarily sell it, but they want to make sure that they get, like you said, the teeth behind it to legally protect that they have created, right? And so they need to talk to an attorney.
Yeah.
If they don't get anything else from this show, don't talk to Aunt Besame and don't talk to your girlfriends. Don't talk to the fellas. Call an attorney. And I'm telling you, I have been bit by these companies that say, come to us and we can help you, because one day when I see you, I'm gonna find that book And I'm gonna tell you my invention in that Toys R Us book. I cried. I could not believe it.
Yes,
They
people do
made a
not,
lot of money
not
off that.
talk to people about your ideas without it, one, being a lawyer, or two, you having executed non-disclosure agreement.
Say that again.
Do not talk to people about your ideas unless, one, you're talking to an attorney, or two, you have them sign a non-disclosure agreement, because people will steal your ideas.
Yep, and that is a good way to end the show. Thank you so much, Ashante. You stay on. Everybody, I would like to say thank you again for joining us tonight. You can join us every Wednesday at 7 to get a new inside perspective. I'm your host, Tina Dawson, the owner of True Blue Designs, and I'm going to say good night. See you next week, same time, same place. Good night, everybody. Wow.